Welcome. You're watching the Moody Lawyer. Justice served with experience and integrity.
Hello and welcome to the Moody Lawyer with attorney Josh Moody. Thanks for being here today. We're hoping we can bestow some great knowledge on you all. Josh, welcome. Thanks so much for being here.
Hey, thanks for having me.
So today we're going to talk about navigating criminal defense from arrest to courtroom. So can you kind of walk us through what happens after someone is arrested and how you get involved as a defense attorney?
The first place to start is what kind of arrest is it? And in California, we have three types of crimes. We have felonies, misdemeanors, and what are called, sometimes you have infractions, and then you have wobblers. And a wobbler can be something that's felony or a misdemeanor. That changes how I get involved in how a client will come to the office. We can start with felonies. Typically, a felony will occur. Police officer will make an arrest, and the client will either be in jail, and a family member or somebody will call me, and we'll go to them and try to visit them and see what the case is about. And the other way is they get arrested and they bail out, and then they come in and see us before their first hearing. That's two ways with the felonies. With misdemeanors in California, you can get arrested, but you typically get a ticket and you're out in a few hours. Most common is probably DUI. You get your DUI, you sit in the cell for a few hours, you sign your ticket, you get a court date that you have to return, and usually people come and see us right away. That's my advice, is to come see us right away. Some people wait too long, and you may be giving up rights by waiting too long and not asserting some of those rights. So that's typically with the misdemeanors. You come in and then we take the case and we make sure, all the court dates are made. And then the final ones are infractions. Those are typically your traffic tickets. You have a court date that you have to go to. Those are not things that you typically get arrested on. Those are things you get, like I said, usually a traffic ticket or some sort of citation. And usually reports are not prepared. They're just one form or two, and you have plenty of time to go see an attorney for that.
And what you mentioned, wobblers. What's a wobbler again? I never heard that term before.
Well, a wobbler is something that can be charged as a felony or a misdemeanor. And so it would depend on what the arresting officer or the arresting agency wants to charge it as. The way it usually goes is the arresting agency will charge it as a felony, put you in jail, try to keep you in jail. And we try to make it a misdemeanor and either get you out or get a lower bail. Rarely is there a charge where the arresting agency tries to make it a misdemeanor and then the district attorney makes it a felony. It happens, but it's very much on the low end, the low percentage side. Typically, crimes like that fall under are typically domestic abuse. That can be charged as a misdemeanor or felony, depending on subjective observances of the officer. The amount of injuries can make it a felony or misdemeanor. So if in the eyes of the officer, this rises to a felony, they'll charge it as a felony, but we try to get it treated as a misdemeanor. And then same thing, they could charge it the arresting officer can charge it as a felony, but by the time it goes to court, it could be made a misdemeanor. So that's what a wobbler is.
Okay.
Something that could be either or depending on the circumstances. And like I said, mostly, a lot of times, it's domestic type abuses. That's probably the biggest one.
Like most people, I know everything I know about law is from Law and Order, and I've never heard wobbler before. So
I assume they have wobblers in New York, but maybe it's getting too much in the weeds.
Yeah, it might be.
But,
yeah.
And maybe they don't do it in New York, but in California, it's just a technical term, but it's how it's charged. So if it is charged a felony, it's a felony until it becomes something else. So, yep, that's the word for the day, wobbler.
Wobbler, word of the day. I like it. So how do you approach building a defense strategy for clients when they're accused of a crime? Like, how do you start the process?
I start the process very, very simple, basically by starting at the very beginning, just like any other conversation. When you meet somebody, whether it be on the streets, at church, in the store, just get to know the person first and them get to know me, because there's a relationship that has to be there. We don't have to be best friends, but we have to know each other and rely on each other. And I have to know you're not going to do things that are going to make our case worse, and I'm not going to do things that make your case worse. It's your case. It's you're the one being charged with something that you may or may not have done. And that's one point I tried to get across, is you may have done something, an act may have occurred, but that doesn't mean with what you're being charged with is the correct charge. And that's a lot of what we do. So I really start from the moment you come in the door, let's just talk. What's going on? And we just try to build that relationship. And sometimes it doesn't gel. If it doesn't gel, I may not be the right attorney. You may not be the right client.
That's interesting. Yeah, I guess it's like so many other things in life. Like you have to gel with that person. You have to click in some way. And I guess you don't think about that with a lawyer-client relationship. But yeah, it's like anything else.
It is. And we are going to be working together for the next few weeks, few months, few years. I mean, I've had criminal cases that last several years but by the time it gets to trial. And so to build upon that, it's just relationship building at that point. And then the next step is, okay, why are we here? You tell me in your own words what happened. And I don't judge. I really, and I don't care. It's not my job to judge, and it's not my job to care about what you did or didn't do. It's my job to hear what your position is and what your side is. And of course, from the moment you call, everything is protected under attorney-client privilege. Even if you call and no attorney-client privilege is attached, I still am not going to go around and tell people that you called or that I heard something that you may have said. That would be an ethical violation. And again, a little disclaimer, just because you call does not establish an attorney-client privilege. Just like watching this podcast does not establish an attorney-client privilege. But I still have duties of confidentiality that if you tell me something thinking that one will be created, I can't repeat it. So that initial interview, the initial consultation is just me trying to figure out what's going on and what your side is. And a lot of times, most of the times, people miss facts or parts of their story because they don't understand how that it's important. But it doesn't matter at that early stage. It's a building. We're building and we're building a foundation. Sure. That's what happened. That's what happens when somebody comes in for the first time, maybe the first 2 times, and we try to figure out what's going on, and we build from there.
There's obviously, I made the joke before about everything I know being from Law and Order. So there's a lot of misconceptions about criminal defense. There's a lot of times people don't realize the reality of what the legal process is. What are some of the common misconceptions you run into the most, and how do you educate clients about how it really works?
Very common misconceptions. Probably the most common misconception is they have time. The government has time to charge you. They don't have to charge you right away. So let's going back to our original example. Somebody gets arrested for a felony. They bail out. You have to keep showing up for your bond to make sure your bond is okay. But the district attorney may not file charges for weeks or months. And I have clients who it's like they want to be charged. I can't force them to do that. And I'll tell you that there are attorneys out there who feel like they're doing their job, and they will call and complain to the district attorney that it's taken too long. Well, I'll give you a little story here about what happens with that situation. And this happens when people try to make it look like they're working, but they're really not. You have a multi-defendant case. One of the defendants comes in to see an attorney. They're upset. They didn't do anything. They're innocent, and they may be innocent. Who knows? Some of the other people are not. But the defense attorney will make a call and say, "I want you to charge my client needs to be charged, or you need to, or you have no case." This is what happened in this case. You have no case against my client. My client didn't do anything. Well, all you have is his side. Well, what happens is the DA. This is the best part. Not for the client. The DA pulls the case, looks it up, and says, "Oh, we overlooked this guy." And they're coming up on the statute of limitations. You may have just argued yourself into filing charges against your client, and it could have just been dismissed because they missed the statute of limitations.
Right.
Patience. It's always patience. And that's part of my job, is to preach patience to the client. Let them charge you. Let's wait for the charging document. Then we'll handle the next step. And a lot of times clients do, the misconception is, well, what happens? What happens? What happens? Well, it's a step-by-step process. Let's get the charges first. If they didn't charge you with X, but they charged you with Y, we don't have to worry about X. Mm-hmm. So that's one of the misconceptions, is that things take place really quickly. Same with DUIs, especially here in San Bernardino County. Sometimes a district attorney gets behind on cases, and what should take a 3 or 4 month filing, they may be 4 or 5, 6 months behind on their filings. That's just, it's cyclical. They may be, right. That has nothing to do with them not doing their job or trying to mess with people. It's just sometimes they get more misdemeanors and other times they don't. So we wait for the charging document, see what you get charged with. So that would be the next step.
Yeah, it's a good point. Again, like everything you see in TV and movies and stuff, everything moves so fast, because it has to.
Is wrapped up.
Yeah, you have to have it up wrapped up in a little bow by the end, and it's an hour. It's a 40-minute show or whatever, and you only have a little bit of it to do your case. So I mean, like, yeah, it's we're conditioned to feel like this process moves fast, but it makes sense that it does not.
Well, that's actually a great statement. What you said there was that we're conditioned to think that. Well, we're
Right.
conditioned because we watch TV, and Law and Order is a great TV show. I mean, it's 20 plus years, multiple spin-off. It is a great show, but it is a story. It is storytelling.
Yeah, I gotta believe there's someone like you watches that and you're like, nope, that's not how that works.
Right, but I'm also not going to Law and Order for legal advice. I'm going to Law and Order to be entertained.
What? Really?
Yeah, it's because it's great entertainment. You're coming to my office not to be entertained. You're coming to my office to get a great result and to be treated fairly and to be treated right.
Good point.
So we kind of have to bifurcate that, change some conditioning. This is not entertainment. This is real life. It may be accurate in many, many respects, but their main focus is storytelling. Their main focus is getting TV ratings. My main focus is getting you the best results you can get based on the facts and circumstances. Yeah.
Yeah. It's not like the writers are lawyers or people involved in the criminal justice system. I'm sure they're probably, most of the time, they're probably not.
They have technical advice, former police officers. And yeah, so there is a bit of reality, but that is not their goal.
Right.
Their focus is to get you to watch the show, not to get legal advice, because we're here talking about legal issues. Let's compare our ratings to Law and Order.
Well, we might be able to catch up. We'll see. Negotiating with the prosecutor. I mean, obviously, again, talking about entertainment, it's always this big grandiose thing and all that. What are the realities as far as how you negotiate with prosecutors and what factors are considered when you're kind of, going between plea deals or going to trial?
The next step after getting a charging document is we then get what's called discovery. And so now I have my client side. Well, now I have the other side. I have the prosecution side. I have the police officer side. Is taken in light of everything that they're saying, can they prove their case against my client with what the evidence that they have and the evidence they're presenting? Can you prove your case beyond a reasonable doubt with what you have? Then there's multiple steps, and there are hearings and there are motions that can be written. But my job is to try to figure out, number one, can you prove the case? If you can't prove the case, then let's move forward. District attorneys do not charge cases just to dismiss them. But if you're interested in a plea deal, like maybe something did happen, but it's not X, it's Y, then we start talking plea deal. And this is what talking to the client and understanding the client's position is from the beginning and through the case. In plea bargaining and dealing with attorneys, the number one thing is just trying to be understanding the other side's position and trying to be reasonable. Understand too that district attorneys have bosses and they have policies. They cannot charge certain crimes and then just dismiss them because you don't think they can do it. Okay, then I'm going to file my motion. Let's take it to the preliminary hearing. I'm going to file some sort of motion to get rid of this evidence that you think you can use. And then if we win that motion, well, now it affects the district attorney's position because now we have some evidence that shows they can't use all of their evidence. Right. So to get back to your question of how do we plea bargain, it's trying to be reasonable, trying to understand what their position is and what they think they can prove. And then the burden shifts to us. Okay, how can we refute some of that evidence? A lot of times, TV, that's just somebody, two people are arguing and, somebody makes a great comment and they decide to get rid of the case. Well, that just doesn't happen in real life. Like I said, district attorneys don't charge cases just to dismiss it at the end. And I hear this, and I hear other attorneys make this argument when they're plea bargaining or discussing a case with the DA of, well, you can't prove this. And the DA is like, well, I think I can. And the defense attorney will just keep saying, no, you can't, no, you can't, no, you can't. Well, you're not going to change their mind saying that. Okay, right. Let's go to the judge. Let's go right. Yeah, let's set this. And that's how you get things done, is by just, kind of like putting up or shutting up. But you're not going to change a district attorney's mind by just saying, well, you can't prove this. Well, they think they can. So
yeah, it's kind of like,
there's an issue.
You sure about that?
And the DAs too, they don't want to waste their time either. So sometimes we'll hire. We have investigators that we hire, and after we get the discovery, hey, here's a report. I sent an investigator out. This is what this witness and this witness told my investigator. Are you sure you want to go forward with this? Typically, a DA will say, okay, give me more. Now I need to do some more investigation. Let me look into that. Sometimes they come back and say, you know what? Okay, yeah, we have an issue with a witness because, some time has gone by. Sometimes they say, no, we're going to stick with the, witness's original state. There's a lot of things that can happen. But what we do is, we'll send an investigator out and try to see if the witnesses are going to be consistent in their statements. And that's kind of how you try to resolve a case through plea bargaining, or trying to get the other side to see that maybe this crime was overcharged. And of course, too, a big thing is criminal records. Does my client have a lack of criminal record? Yes, you can get to a felony, but this is a guy or a woman who's never been arrested before. Is it in the interest of justice to, and then, maybe, and there's a lot of sentencing guidelines we can follow. Maybe we can do this, maybe. So there's a lot of times a deal can be made by knowing how things work, as opposed to just, obviously trying to represent yourself.
What rights do people often overlook when facing criminal charges?
One that's common in DUI cases in California, you get arrested for a DUI. Your license is automatically suspended. You have 10 days to ask for a hearing from the DMV to reconsider the suspension of the DUI hearing. That's probably one of the biggest things. They get their ticket, they get out of court, they take 2 weeks to find an attorney, and by that time you've already missed your DMV cutoff. And unfortunately it's happened. And then, we get the case and they really didn't have any authority to even, the DA doesn't charge. And, this person's license was suspended for however long, even though it shouldn't have been. So that's one right that typically people give up. Two, you also have a right, you have a right to have an attorney present at arraignment when you're charged. Oftentimes you don't get public defense. Sometimes, especially in misdemeanors, the court will read you the allegations against you, and then they assign a public defender. Again, technicality, but those are things that, you don't know going into your case until after you've either been charged or about to be charged. So you don't know until that day. In California, you don't get a public defender a week before, 2 days before. You don't have anybody explaining the process. You get appointed when you get charged, and you have to report to their office. So, that's why we try to keep people informed. And especially on DUIs, we've already gone through a DMV hearing, or we've gone through some type of other admin hearing. So we already have a relationship and rapport before you even get that charging document.
Right. All right. Well, that's some great stuff, Josh. That's some great advice. And thank you all for tuning in to the Moody Lawyer with attorney Josh Moody. If you want to get in touch with Josh, his website is moodylawyer.com. Don't forget to like and subscribe this video and stay up to date on all things law in California. Josh, thanks so much for being here. It was great to see you.
Great to see you. Have a good day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.